Okay, thank you, Your Honor. Would you
And
prefer?
just for the record, and for people watching, this is against the individuals, Rickye Henderson pro se and Mr. Meeks, who's represented by Miss Mia Alexa, I believe.
Alexia.
All right, Mia Alexa.
It's Alexia Law Firm.
Okay.
And so we only represent Mr. Meeks individually,
Right.
no other entities.
January 3rd, 2023. Again,
nice.
approximately 2 hours after they were personally served with the TRO, Curtis Meeks directed his agent, Rickye Henderson, to administer the deed of trust. Basically, they enforced an invalid fraudulent deed on the property. This is a violation of Section 2A of the TRO. This is violation 1. And if you look at the trustee's deed, D8, you can see that there is a clear violation as in the deed records themselves. Okay.
Anthony was never on the case.
So yes or no? 5 attorneys so far.
No.
Okay, how is that wrong?
Okay, well, you can go to the next question.
Okay.
All right, Curtis. So we're going to focus.
Okay. Through this litigation,
All that's inappropriate.
what was your intent in signing and filing this quitclaim deed on February 2nd, 2022?
Oh, thank you.
And
Because I don't
Mr.
know.
Meeks is going to take the Fifth Amendment at this point.
Okay.
Take the Fifth Amendment, Mr. Meeks.
Okay.
My
And
take
it's
on
a
what?
violation of his Fifth Amendment rights.
He hasn't asserted it yet. He said
I'm
he'd answer.
advising my client to not answer the question.
You don't get to do that. This isn't a deposition.
That isn't how this works.
September 30th, 2022,
Oh,
the
here we
Top and
go.
Ball LLC received discovery in this case.
Your Honor, at this point, I am going to have to withdraw on this case. So the
That's
case,
denied.
well, the case cannot proceed further.
You can't withdraw mid-testimony during a hearing.
And take the
Nope,
Fifth
nobody
Amendment
was
again.
enforcing anything.
Curtis, you're to take the Fifth Amendment again. Invoke your right.
Take the Fifth Amendment.
All right.
Your Honor, I ask to admit Exhibit D8, the January 3rd, 2023 trustee's deed into evidence.
Any objection?
All objections. Curtis Meeks has invoked his Fifth Amendment.
We still have someone listed as iPhone 2. If you can please rename yourself.
Or just
You can
tell
tell
us
me.
your name and we can add your name.
Yes.
Curtis Meeks. You saying me?
Thank you. Yes.
Yeah, Curtis Meeks.
MEENK. Oh, it's
No,
right.
MEEKS.
Thank you, Michelle. The 345th District Court is not in session. The Honorable Jan Swift is deciding.
Good morning, everyone. We have a 1 hour hearing set this morning on a motion for sanctions by the plaintiff. I have reviewed what y'all have filed. Each side will get up to 30 minutes. Ms. Fatima will keep track of the time. And so, Mr. King, you may proceed.
Thank you, Judge. And I'll just, if you reviewed the file, I'll try to move through this quickly and will not need to use even our 30 minutes. I'm going to share my screen really quickly, if I may.
You may.
Okay, so this is a motion for sanctions, and we're asking for a default judgment as the sanction. Your Honor has already granted summary judgment with respect to plaintiff's primary claim, which is a quiet title claim. There are remaining claims that would be the subject matter of this default judgment. And so I will just walk through the basis for that. So as Your Honor may recall, plaintiff had a motion that was heard last in November 13th motion, where we requested a forensic examination of the defendant's electronic devices, and we asked for a spoliation instruction. And the evidence that we presented with that motion was that evidence had been fabricated, that there were untruths, false statements about evidence being destroyed. There were claims about Mr. Meeks being illiterate, which were not true because there were many communications. And there were refusals to produce the documents and recordings that we knew existed. And so that was the basis for the motion to compel a forensic examination. And the court ordered that relief in a November 28th order, and specifically found that the defendants had committed discovery abuse and that they had actively and intentionally concealed discoverable evidence. And the court found that they likely spoliated evidence. And so here is the language right from Your Honor's order. It was ordered that within 7 days of November 28th, the defendants were to turn over their electronic devices to a third-party forensic examiner, R3 Digital Forensics, so that R3 could create an image of those devices. And then the next step after that would have been, were the devices turned over, that the defendants would see a copy of what was made and they could create a privilege log. And so they could withhold anything that was actually privileged, and so plaintiffs wouldn't have seen it. But what actually happened was the defendants refused to turn over their devices. It's undisputed that they didn't turn the devices over. Mr. Henderson sent an email shortly after the order was issued saying that the devices don't exist. And he made the claim that we had hacked his computer and stole his phones. Mr. Meeks didn't make any statement like that. He just didn't say anything, and he refused to comply. Later, we found out why. For Mr. Meeks, before the court deadline, which was December 5th, to turn over the devices, we heard nothing. After we filed the motion to compel, or rather the motion for sanctions, then Mr. Meeks scheduled an appointment with R3, but we have the declaration from Mr. Lilly, who's also here with us. I don't think we'll need to call him because his declaration has been filed. But Mr. Lilly from R3 reported that Mr. Meeks showed up on December 22nd, and he just refused to hand over his phone. And there are actually multiple phones. There's not just one phone, but he showed up with one phone. He showed Mr. Lilly the screen of one chat string with plaintiff, and he asked for that to be recorded. And then he basically said, that's all you're going to get. And so this is from the declaration. He said, as far as he was concerned, that contact card and message were all we were going to get, and he would tell the court the same. So Judge, it is within your discretion and power under Rule 215.2B to order sanctions for these discovery abuses. And it's a discretionary standard. I've got the standard from the Dallas court. The choice of sanction is left to the sound discretion of the trial court. And one of the specific sanctions that's permitted under 215.2B is to render a judgment by default. And so just so Your Honor is comfortable with that remedy, I've outlined in our motion and here kind of what the standards are that courts consider for when to order a default judgment. And it is when the conduct is such that it justifies a presumption that the claims or defenses lack merit. And so that standard can be met in different ways. One way that can be met is if there's enough evidence that the party has engaged in pervasive and persistent obstruction of the discovery process or bad faith in the litigation process as a whole. So if there's that sort of overall bad faith, that's one basis for a court to say, there's a default judgment as a sanction. That's one basis. The other basis is if a party refuses to produce critical evidence. And if a party refuses to produce critical evidence, then that would warrant the belief that a full and fair disclosure would be damning for the refusing party. That's the language that Texas courts use. And so there's sort of these two avenues to obtain that default judgment as a sanction. And here we have both met, right? Refusal to produce critical evidence. We know that happened. First, defendants did not produce critical evidence and the court ordered a forensic examination. And then on top of that, they refused to comply with the order and didn't turn over their phones. So that refusal is in the record, undisputed. There also has been just bad faith overall in the litigation process. As in our motion to compel, we described the false statements aimed at avoiding discovery, fabricating evidence, concealing evidence. Those are that type of repeated misconduct. And then here, just ignoring the court's order, that shows bad faith that justifies this type of a sanction. And any lesser sanction wouldn't be appropriate at this stage. The court has already ordered what was a very stringent remedy. A forensic examination is not granted lightly, and Your Honor chose to do that. And so we're already at the end of the line. There's really not much more that could be done here to deter the defendants. All that any other lesser sanction would do would increase the plaintiff's attorney's fees here, probably not get any new documents. And we've got a January 22nd trial date. And so it would just severely impede plaintiff's ability to present the case when he doesn't have all of the evidence. And frankly, plaintiff does not have the means and wherewithal to continue spending attorney's fees on this case. And so he's in a difficult position, and further attorney's fees are very detrimental to him. And so the appropriate result here is a quiet title. That claim has already been granted. The remaining claims, breach of contract and fraud, because of the discovery abuses here, a default judgment is warranted. The defendants haven't filed any response to the motion. And so rendering default judgment will be just, which is the standard under 215.2b, to spare plaintiff the additional expense and the prejudice. And that's all we have, Judge.
All right, thank you. So who is going to take the lead for the defendants, or have y'all decided who's going first?
I mean, I can go and speak on my behalf.
Yeah, hang on. I'm representing Curtis Meeks. I do not represent Rickye Henderson. And I'll call Curtis Meeks to the stand.
All right, Mr. Meeks, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may proceed, Mr. Morin. You are off camera. We can see your ear, but not your face. There we go. Thank you.
All right. Sorry, Judge, I was looking at the wrong screen. Mr. Meeks, did you receive the order and instructions telling you to produce your phones at the I can't even remember
the
what was
R3,
named.
whatever, the R3 place or whatever.
Yeah, that's it. And did you appear at the appropriate date and time and deliver your phones?
Yes. I came in there at the exact date what they told me to go to. I'm doing everything they asked me to do. And he know the lawyer know, Ali's lawyer know that Ali texts one text and I text one text. And he just texted that recently. We have two texts. I showed him what they wanted to see. So as far as he's talking about, I don't know what he's talking about. He's just straight line in the courts, but go ahead.
All right. So did you produce all discoverable evidence on your phone?
Yes, he got everything that they need from my phone.
All right. And hang on. Let's see. When did you first meet Mr. Ali?
I met him through Rickye.
All right. And that was around September of 2022.
I don't remember what exact day it was. I met him through him. I don't remember the exact date.
Okay. But that's when you guys entered into the lease in September 2022, right?
Yeah, that's when we got agreement and signed not only the lease, the deed, and the lease. There's nothing about no lease with me. I mean, he wanted me to sign, I guess, for some liquor license or something, or I don't know. But they taking my money, and then I don't think that I'm spending money on lawyers and they saying I just supposed to lose everything, and it's not gonna go like that. So that's why we're in courts, and I understand he's talking about sanctions that we didn't do. Well, I don't know about Rickye. I'm talking about me. I did everything the courts asked me to do. So we need to go to the trial, and we need to go ahead and get going. We don't need to keep saying like I did something wrong for me spending my money.
All right. So you turned over and allowed this company to make copies off your phone of the 2 text messages that there were, right?
Right, of Ali. That's what they asked for. And I made sure the guy recorded and everything. I gave him my phone, made him scroll down, went to Ali number, and he recorded and everything. What else more do they want from my phone? Like I don't understand it. But I did what the courts asked me to do. So he's saying I didn't do that. I did do that.
All right. And there's no discoverable evidence that would not be privileged, like communications with your lawyers on your phone, right?
I mean, I communicate with my lawyers, but he asked for Ali and all that. Like,
I know. I'm just telling you, asking you, were there communications on your phone with your lawyer?
yes.
All right. And were there communications on your phone with Rickye Henderson?
Yes.
And those are privileged as well because you're common defendants. And that's the common defense doctrine. Correct?
Right.
I'll pass the witness.
Mr. Meeks, so you did not attempt to or actually meet with R3 on or before December 5th, correct?
No, it ain't no did not. I met with him. Don't say I didn't meet with him. I met with him. I don't know. I forgot what date it was. Your guy got the date and he got the recording on his phone. So I met with him whatever day it was.
After December 5th, wasn't it?
I don't know what the day was. I forgot. I don't know what the day was. He got the recording of the date where he seen the phone.
And
like they asked to go up there.
when you met with them on December 22nd, you only were willing to show him these 2 text messages with Ali, correct?
The same text message that you saw on Ali's phone, correct?
You were not willing to just hand over your phone.
No, I hand over my phone.
You were not willing to allow R3 to copy all of the content of your phone, correct?
I was not allowed to give R3 my phone to have it overnight, correct? I wasn't letting him keep my phone to keep it overnight. That's what I won't do because I have other business that people have to call and I take care of other things. So I wasn't giving him my phone to keep overnight. So yes, that's correct.
The only thing you would give them was the 2 text messages, right?
What he was looking for, what he asked me for. Right.
I'll pass a witness.
And you doing so was in compliance with the court order to give them all discoverable evidence, correct?
Correct, of what Ali, that's what they asked for.
And that order gives you no more instruction other than to give them all discoverable evidence, correct?
Correct.
All right, pass the witness.
I have no further questions.
I do. Mr. Meeks, have you seen the order that the court signed on November 28th?
I mean, my lawyers see all that. I don't read or do nothing of, man. I let the lawyer, and then if they tell me what I need to do, I do it. But far as you talking about the order, could you explain it to me so I can have a good understanding? Maybe you, Ted, can tell me something that the lawyer didn't tell me.
All right. Did you read the 3rd paragraph of the order, which says, it is therefore ordered, and maybe Mr. King, you could share the screen and show him the November 28th order, the first page?
Yeah, I can. Give me one moment.
So the third paragraph, oops,
Sorry, Judge.
no problem. It was fine. Go down to the next paragraph. Yeah, that's good. That third paragraph says, it is therefore ordered that within 7 days of the signing of this order, and the order was signed on November 28th of 2023, defendant shall provide any cell phone, computer, email account, or other electronic device that is likely to have discoverable evidence to R3 Digital Forensics or any other independent computer forensic expert appointed by plaintiff, who will create a forensic image of such devices and/or accounts. The forensic evidence shall then search for documents containing any term provided by plaintiff. The temporal scope of said searches shall be from August 1, 2022 to the present. Have you seen that order and read that paragraph?
I haven't seen none of this order, but my lawyer probably seen it, and he probably was trying to explain it to me.
All right.
But
So the order required you to hand over your cell phone, computer, email account.
I don't have a computer, man.
All right. And then it ordered that the expert would provide to your lawyer all documents that are responsive, and your lawyer then will hand over all documents which are not privileged and a privilege log for any withheld or redacted documents to plaintiff's counsel. Were you aware of that?
I mean, whatever the lawyer told me, that's what happened. I mean, I'm not aware of what you're saying as far as with the privilege and all that. I'm saying what my lawyer told me, and I'm trying to do everything he was asking me to do.
All right.
But I'm saying I did it. I don't know what seems to be the problem.
You did not hand over your phone and allow them to make an image of everything on it.
No, I did hand over my phone. I mean, I don't know what he did with it, but I did hand over my phone. So don't say I didn't hand over my phone. I did hand over my phone.
You showed him 2 texts on your phone.
No, I handed it to him. He got it and put it in his hand. And I showed him, and this is Ali's number, and here's the text message that we talked about. And if you go on Ali's phone and see the text message, it's the same 2 text messages, or unless they erased it or whatever the case may be. But I did give him my phone.
Thank you. Mr. King, do you have any follow-up questions?
I don't. I'll just add one clarification. Mr. Meeks, when R3 told you that they wanted to take a copy of everything on your phone, you told them they could not do that, correct?
He never told me that.
So you're just denying that they said they needed to take a copy that was more than just.
I gave him my phone. He asked me where Ali's number was. I showed him what the number was, and here's the text message, and there it was. He recorded it, and that's what it was.
All right.
I mean, I do
Anything
something
All right,
wrong.
Judge.
Anything further, Mr. Moran?
Yes. The plaintiff never designated any topics for RG3 to look for.
I'm sorry. I meant, do you have any more questions for Mr. Meeks?
All right. I'm sorry. No.
All right. Mr. King, you may call your next witness.
Judge, I think we have a declaration of Mr. Lilly. I think we'll rely on that declaration unless there's any need for, unless Your Honor would like to hear the same description from him.
I would like, now that he's heard what Mr. Meeks had to say, I'd like to hear his description of what happened.
Okay, I'm going to pass it over to Mr. Alarcone for that questioning, Judge.
All right. Let me swear you in, Mr. Lilly.
Okay.
Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Lilly.
Can you please tell the court what you do for a living?
I currently work for R3 Digital Forensics as a digital forensic examiner.
Okay. Can you briefly describe your job duties as a digital forensic examiner?
So there's two parts. The first part is forensically imaging devices, mobile devices, computers, extracting the data off of them to preserve them for later analysis. The second part is then the analysis of that data. And in the instances of these cases, we're usually given protocols by attorneys to look specifically for things within that data, then to present back to the attorneys.
Okay. And Mr. Lilly, you have seen the court's November 28th order that we were just discussing?
Yes, I have.
And that order instructed R3 Digital Forensics to create a forensic image of the defendant's electronic devices, right?
Correct, yes.
Can you help me understand what a forensic image of an electronic device is?
So basically, it's a little bit different in computers and mobile devices. In computers, we're pulling the data off the computer bit by bit. It's an exact copy of what's on the computer. Mobile devices are different because the data is constantly changing. So with mobile devices, we extract the data as it is at the time, and then preserve that in a manner that does not get changed.
Okay, and when someone says forensic image of an electronic device, does that mean all of the data on the electronic device?
Yes, the way it works is we either pull all the data or none of the data. We can't pick and choose.
Okay. You met with Mr. Curtis Meeks on December 22nd, is that correct?
Yes, that's correct.
And the purpose of that meeting was for you to create a forensic image of Mr. Meeks's electronic devices?
Correct.
Can you tell the court what happened that morning?
He arrived around 9:30 in the morning, and I brought him into our data intake center, and he showed me his phone. He had the contact for Mr. Ali pulled up and asked me to take a picture of it. So I thought he was just wanting to get information off the phone. And then he wanted me to record because then he showed me the messages between the two of them, the one chat bubble each, and asked me to record those. I pulled out my phone, started the video, and recorded both of them. But then I told him that as far as we were led to believe, that he was going to hand the phones over to us so we could do the forensic image of the device. And at that time, he said that's all we needed was those two things.
So Mr. Lilly, Miss Williamson shaking her head, which means you're speaking too quickly. So I'm going to ask you to slow down a bit.
Okay.
So let me ask a question. Did you explain to Mr. Meeks that you needed to do a forensic image of his phone?
Yes.
And did he allow you to do a forensic image of his phone?
He did not.
How long would that have taken?
It depends, usually between 4 hours and 8 hours, depending on the type of phone, the amount of data on the phone, and if we run into any issues.
And did you tell him how long you needed to have his phone?
I did not.
Did you tell him you needed to have it overnight?
I did not, because in some instances we can get back the same day.
Sorry to interrupt. Go ahead, Mr. Alarcon.
Just one last question. So Mr. Meeks did not allow you to do a forensic image of his phone?
Correct.
Pass the witness, Your Honor.
Mr.
Did you have the phones in your hand, sir?
Briefly, I did, yes.
Okay, so you could have kept them in your hands and did the forensic image, correct?
No. He wanted the phone back after I took the video of the messages and the contact card.
But you had the phones in your hand.
Yes, but I was not going to argue with Mr. Meeks about keeping it for an extended period of time to create an image.
No further questions.
All right, just to be clear, Mr. Lilly, you told him you needed to make a forensic image of the phone, and he said what?
He said that the chats and that contact were all that, as far as he was concerned, that we were going to get, that we were not going to get all of the data off of his phone because he had to go to work that day and he had videos and pictures on there that he didn't want anybody to see.
All right, so you asked to take it, to make a forensic image, and he said no.
Yes.
All right, anything further for Mr. Lilly?
Nothing
No.
from me, Your Honor.
Do we know?
Not for me, Judge.
Thank you. Do we know who J. McNeil/M. Adams is?
I believe that is the plaintiff, Mr. Robsdigan. He's in our office.
Yes, Judge, it is.
All right, thank you. He's just using somebody else's computer.
Yeah, he's using one of our office computers. He's in our office here.
All right, thank you. All right, is there any other evidence that you all want me to consider, Mr. King or Mr. Alarcon?
No,
Your
Judge.
Honor, there is one thing attached to Mr. Lilly's declaration is an email that R3 Digital Forensics sent to Mr. Morin. And in that email was explained to Mr. Morin that the forensic imaging was going to take several hours. And that was, of course, before Mr. Meeks took his phone in.
All right, so remind me of the date you filed that motion. Oh, I see it, 12/14.
Correct.
All right. And so the court does take judicial notice of its file, including the motion and its attachments. And for the sake of time, the court is going to accept the remainder of Mr. Lilly's testimony by way of his affidavit, which is, which exhibit number is it?
That, Judge, was attached to our filing yesterday. It was a notice of supplemental evidence. And it's Exhibit 6. It's identified as Exhibit 6. And we uploaded that to Box. It might not be in on your file.
Correct. I do see it, and I do take notice of it as well. All right. So, with that, do you all rest?
We do, Judge.
All right, Mr. Morin, do you have any additional evidence you'd like to put on?
No evidence, Judge, just argument.
All right. Well, let me hear argument first from the plaintiffs.
Yes, Judge. Nothing that you've heard from the evidence changes any of the points and arguments that I made in my opening arguments. What you heard from Mr. Meeks was confirmation that he was only willing to provide a text message string. And you heard confirmation from Mr. Lilly that Mr. Meeks refused to hand over his devices because he did not want information to be received. That's just clear defiance of the court's order. It was intentional, and it is completely in line with the prior repeated instances in which the defendants here have refused to comply with discovery requests and orders. So, Judge, and we have not even touched upon Mr. Henderson, who, just to remind Your Honor, is a co-conspirator in all of the activities here. And so for Mr. Meeks, who has not complied with the order or discovery requests himself, but for him to try to hide behind Mr. Henderson's refusal to produce his own incriminating documents is not any type of defense. And
so let me just ask, did Mr. Henderson hand over his devices?
He did not, Judge, and that's undisputed. The evidence in the record is an email from Mr. Henderson falsely claiming that our office hacked and stole his phones. And just to remind Your Honor, Mr. Henderson was the one who essentially on behalf of Mr. Meeks, who was claiming ownership of the property, submitted an insurance claim after the property burned down. And they both signed the lease, and they were both there during the fraudulent scheme to have Mr. Arabzadigan sign the fraudulent quitclaim deed. And so the only defense that is being put on here is by Mr. Meeks. Mr. Henderson there's nothing here in defense of his actions. And these defendants are in this together. And the appropriate order here is a default judgment for the claims that are against both of them in light of the inability of plaintiff to obtain the discovery that would shed even further light on their misconduct. This is exactly the type of series of misconduct in discovery that warrants the sanction that we're asking for. As I mentioned, Your Honor has already gone to the brink and ordered a forensic examination, which is a very extreme remedy and sanction for discovery abuse. And after that, the defendants have failed to comply with that. Nothing else is going to deter them. And default is appropriate here.
All right, Mr. Henderson, you have your hand raised. Did you have something you wanted to say? You're still on mute.
Okay.
Go
Can you
ahead.
hear me?
Yes.
Okay. First of all, ma'am, my son was murdered October the 4th of last year, and I still reserve some suspicions that the plaintiff had something to do with it because of his intent or his desire to kill innocent people, which you could hear in the recordings. I signed a lease.
Sir,
I'm getting to it.
Let me just give you my condolences on the loss of your son, but let's address the motion.
Okay, so I know you don't want to hear it, and I know this tribunal is racist on that. All I'm saying is this guy started off saying that we forged the document and that he never signed the document in front of a notary. These proved to be lies, and those are criminal offenses as for number one. He said that we signed his name. So in order to get here, all he's trying to do is deflect from the real facts of this, that he did sign these things, that he did lie, try to put us in jail for nothing. He said that we forged, that was proved to be a lie, but I know that the courts don't really want to hear that. They only want to hear something that is so minor to me, because he committed a felony against us from day one. If we didn't have a video of this here, then we two black men would be in jail. And for you to entertain us, the courts to entertain us, I understand that, or whatever, and however y'all do this here. But the real thing is that this guy here said that I forged the document. This has been proven to be a lie, but the courts don't care about that. This guy said that he never signed a document in front of a notary. This is a lie, but that's nothing. But when it comes to some white firm or whatever against two black guys, you don't listen to the black guys, you listen to the white guys, or in this case, a foreigner who has admitted on live testimony that he doesn't like America anymore. But to come here and focus on one thing instead of the facts of the case, that he signed this thing willingly and it wasn't no trick to it. And now you come down to some discovery that you want to have and hear so it can deflect from getting to court, is injustice in itself. And I already know, like I've explained, that my phone was stolen. And I said to them, it's okay for them to lie to the courts with no repercussions, even committing a criminal offense. And you to entertain that, I already know that our chances here are very limited. Only thing I'm saying is I didn't take anything. He signed the thing. He took our money. He took his money. And the reason that I did the insurance. I'm the one who paid for it. I'm the one who got the insurance to try to protect this dude's property or whatever's going on right there when he signed it over. And this is just a bunch of malarkey. And I know that we are the only one that's going to get penalized out of this. And that's what I needed to say. And thank you for your condolences of my son. And like I said, this guy here, hold on, baby, I'll come to you. And this guy here started offline, and the only thing that they did is construct, well, we're going to use their past, we're going to use this, we're going to construct this defense to make them look bad, and we're going to deflect away from what really happened and just use their history. They came into the courts, even the judge. Oh, that's why they call you slick. I haven't even had an opportunity. All this, you and the whole courts ignore me. I didn't even get he said that I got a motion. I ain't even remember getting a motion. They don't send a lot of documents to me. I just asked them for the discovery that they sent where it had in the documents. Well, the did it. They have it. They probably showed it. They say the did it. You know what I'm saying? And but we're going to disregard all of that, and we're going to talk about some text messages or some phones to look for something else to convict these over something which is, I think, is just a disgrace to the justice system. But go ahead and do it however you want to do it, but just know that he came in from day one and said that we signed a document, which we did not, is video proof, and that he never signed a document in front of a notary, and that he didn't sign a deed, which he did because his deed is a separate from his lease, and he knows that, the lawyers know that, and I'm quite sure that the courts know that. And that's what I had to say.
All right. Are you going to address the motion that is before the court today?
Okay. The motion, I said that I lost my phone, but I could tell you that I've produced everything that I've had. And I do believe that someone hacked it. All the information is gone. So what am I supposed to do? And
you're telling me that as of right now, you do not have a phone.
yes, I'm telling you, as of right now, I don't have my phone.
You don't own a phone, a mobile phone right now?
I have a history of a phone, but I don't have one now. It's gone.
And you don't own a computer?
No, I borrow computers. I'm poor.
And
of course, the courts are at their liberty. You don't have to believe me. And I know that you don't want to believe me because you don't want to go against this firm because they're so good at donating or contributing. But if it's getting to a phone to look for what? Did he sign the deed? Yes, he signed it. Did he sign the lease? Yes, he signed it. If that's what we're supposed to look for. That's what we're doing. But looking for some text messages to see that he didn't sign the deed or he didn't sign the lease, we're not going to find that because he did it on his own free will. It wasn't
all right,
no choice.
Mr. Henderson, that I think you have answered my question. And
yes,
let me just say that I find your accusations about me offensive and untrue, and inappropriate to discuss in open court.
I apologize. I was just giving my feelings.
I understand. You have any other information you want the court to have before I make a decision on today's motion?
No, ma'am.
All right. Mr. Moran.
Yes, Judge. The plaintiff has already taken a forensic imaging of Mr. Ali's phone. They haven't provided us that information, but we know that they've done it. So once they've got the forensic imaging of Ali's phone, they can look at all the text messages to and any other information they want to Curtis Meeks or Rickye Henderson. Once they have that in their hands, what else do they need? They don't need anything else. There's no other discoverable evidence. The discoverable evidence that was on Curtis Meeks's phone were 2 text messages.
So, Mr. Moore, I'm gonna ask you not to re-argue the motion to compel and just to address the motion for sanctions.
Well, this is part of it. Once they have that,
there is a court order dated November 28th, 2023. I am not revisiting the court order. I'm asking for any evidence or information that you all have that explains why you should not be sanctioned for violation of that order.
Yes, Mr. Meeks complied. He turned over his phones for any discoverable evidence. That's all the order says.
No, that
Is
is not all the order says, Mr. Moran, and I've already read it to you once, so I'm not going to read it to you again, but it ordered to turn over the phone, computer, any other electronic device for forensic imaging.
Well, that's my point. There's nothing on there. If they've already gotten Ali's phone and saw everything that was on there, there's nothing on there to look for. This is totally a fishing expedition by the plaintiffs. It's the worst fishing expedition there ever was. And it's absurd. There's nothing more. He gave you everything that they needed, and that's it. And if they were to get the phones, which you could still do, there would be nothing to find.
All right. Thank you, Mr. Moran. Mr. King, have you uploaded a proposed order?
I have, Judge.
I didn't see it there.
I think it's on box, but if it's not, then we will do it immediately after the hearing ends.
All right. The only thing I see that y'all have uploaded is that notice of supplemental evidence. I also would like you to upload a copy of your PowerPoint, please.
I will, Judge.
All right. Well, the hearing is concluded. I will take this under advisement. I will make a decision as quickly as I can, especially given the fact that the case is set for trial in just a couple of weeks.
And Judge, so let everybody know, I'm deathly ill over here and not being able to work. So with that trial date coming up, I'm going to be asking for a continuance.
That isn't before me today. I'm sorry that you're not well, Mr. Moran, and you are, of course, entitled to file a motion for continuance if you feel it necessary, and some other judge will likely have to take it up because as of this week, I'm on the family docket for 3 months. So I just took this follow-up hearing, but it's going to go back to the central docket. All right. So thank you. Y'all are excused.
Thank you, Judge.
Thank you, Judge.
Thank you.
Thank you, Judge. Have a good day. And I apologize if I offended you in any way.
Thank you. All right. We have that other Zoom on